morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence L. Holmes. I'm the presiding judge here in Jefferson County and County Court at Law number 2. Now, today your case is set on our arraignment docket. And what the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and what options you have regarding your case. The case that you have in this court is a misdemeanor case. Criminal cases are divided into felonies or misdemeanors. Your felony cases are in the district court. They handle cases such as murders, aggravated sexual assaults, serious type drug cases, and a host of other serious cases. Misdemeanor cases, they're normally commonly referred to as a petty offense, but that does not mean that they're not serious. The kind of cases that we handle here are like DWIs, criminal trespass, possession of unlawful possession of a controlled substance. We also handle driving while intoxicated cases. It could be a driving while intoxicated or driving while intoxicated with a blood alcohol concentration of level of 0.15 or more. We also handle burglary vehicle cases, possession of marijuana cases, theft cases, and a host of other cases that are classified as misdemeanors. Now, your misdemeanor cases falls into one of three categories. It could be a Class A misdemeanor, a Class B misdemeanor, or a Class C misdemeanor. Normally, the Class C misdemeanors are those cases that you normally see in the justice court, the JP courts, or the municipal courts. Usually the traffic offenses. And the ones we handle here, we do handle some Class C offenses, but it's only when they are appealed up from the JP court or the misdemeanor courts. But on most of the cases that we handle in this court are Class A and Class B misdemeanors. The Class A misdemeanors, the range of punishment, and the Class B misdemeanors, they have different ranges of punishment. Now, your range of punishment for a felony case, you could get sent to the state penitentiary. You could be given a fine up to $10,000. For your misdemeanor cases, we cannot sentence you to the state penitentiary. However, you could be sentenced to the county jail. Now, if it's a Class A misdemeanor, which is the highest misdemeanor, your range of punishment can be anywhere from 0 days in the county jail to 365 days in the county jail, which is 1 year. You could be given a fine from $0 to $4,000, or you could be given both such fine and confinement. Now, when I say the range, that means you could be given a fine from $0 to $4,000 or anywhere in between. You could be given jail time from 0 days to 365 days, which is a year, or anywhere in between. That's the range. And for a Class B misdemeanor offense, the range of punishment is anywhere from 0 days to 180 days, which is 6 months, a fine from $0 to $2,000, or you could be given both such fine and confinement. Now, you may qualify for probation. There are two types of probation that you may get. One type of probation is called adjudicated probation. The other type of probation is called unadjudicated probation. The difference between the two is that with the adjudicated probation, it does result in a conviction on your record. And because it results in a conviction on your record, you cannot, say, get an expunction. However, there is something that is called judicial clemency. And with the judicial clemency, that means that the court can set aside your conviction and you will no longer have a conviction. And the way it works is you have to, one, successfully complete the probation. And two, you cannot have any more time left on the probation. It has to expire. And three, you have to be discharged, meaning let off of the probation by the court. And if those three things happen, then the court can allow you to come back into court to withdraw your plea. of either guilty or no contest, and any complaint, affidavit, or information that has been filed will be set aside. And then the court can set aside your conviction, and you can truthfully say that you were not convicted in this case. However, if you get a subsequent conviction, another conviction later on, then the case can be resurrected, revived, or brought back up, and it can be used against you. And if you try to get a license with CPS, they could either deny giving you a license, or if you have a license, they can revoke or suspend that license. Now, with the unadjudicated probation, which is different from the adjudicated probation, with the unadjudicated probation, it does not result in a conviction on your record. And because it does not result in a conviction on your record, your case will be dismissed, and you may qualify for a non-disclosure. And what a non-disclosure is, it basically means that we cannot disclose or tell the general public that you were on deferred probation for this case. Now, however, if you violate the terms and conditions of your probation, of your deferred probation, then the state can file a motion to revoke your probation. And if the state files a motion to revoke your probation, a warrant will be issued for your arrest. You'll be arrested, put in jail, and if you can bond out, and then you'll be entitled. Well, first of all, once you're arrested, you will be entitled to a hearing to determine whether or not you violate the terms and conditions of your unadjudicated probation. Now, that hearing will be before the judge only. If the judge finds that you have violated your probation, then the judge can revoke your probation. And if your probation is revoked, you may get a conviction. And if you get a conviction, you cannot get your case dismissed, and you cannot qualify for a non-disclosure. Now, as a defendant in a criminal case, you have three options. Number one, you may hire an attorney, and that information is on the paperwork that has been passed out to you. Number two, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. And number three, you may represent yourself. If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you first sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. At the bottom of the document, it says defendant's choice. Mark initials next to only one choice. If your choice is I want to reset this case to hire an attorney, then the only thing you have to do is put your initials on the first line to the left. If your choice is I've hired an attorney whose name is, you put your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is I want to apply for court-appointed counsel, then you put your initials on the third line to the left. If your choice is I have a court-appointed counsel whose name is, then you put your initials on the fourth line to the left, the name of the attorney, and the line to the right. Or if your choice is I want to waive my right to an attorney and represent myself, then you put your initials on the fifth line to the left. And once you finish initialing one of the 5 lines, you will sign on the line that says defendant, and you put the day's date of May 4th, 2021, where it says date. Now, you also have a right to have a trial by jury. And what this young lady is sitting in that area, we call that the jury box. 6 citizens from Jefferson County will be selected to decide whether or not you are guilty or innocent in this case. You also have a right to waive or give up your right to have a trial by jury, just have your case come before the judge. You can come before the judge either by a plea bargain, or you could come before the judge either by a trial. We call a trial a bench trial. Now, you also have a right to have witnesses to come to court. And what witnesses do, they sit in that chair right there. They can testify for you or against you. And if you have any questions, you can ask them questions. We call that either direct examination or cross-examination. Now, if you don't want any witnesses, you can waive your right to have witnesses to come to court. And so that just simply means you will not be calling any witnesses on your behalf. Now, you also have a right to have what we call discovery. Discovery means you have a right to see the evidence that the state has against you. Witness statements, videos, or whatever type of evidence that they have, recordings. If you desire to see the evidence, you'll have access to the evidence if you're representing yourself. If you have a lawyer representing you, your lawyer will have access to that evidence. You also have a right to waive or give up your right to see the evidence, or you have a right to waive discovery. It means that what that simply means is you do not want to see the evidence that the state has against you. You have that right as well. We call that waiving your right to see the evidence that the state has against you. Now, for those of you who are representing yourself, or for those of you who are represented by an attorney, they'll have an opportunity, your attorney will have an opportunity to talk to the prosecutor to see if they can work out a plea bargain. Or if you're representing yourself, you'll have an opportunity to talk to the prosecutor to see if you can work out a settlement on your case. Now, the settlement, we usually refer to it as a plea bargain agreement. Now, if you are able to reach a plea bargain agreement with the state of Texas or with the district attorney's office, the court, the judge that is, does not have to follow that agreement. If the court does not follow the agreement that you have reached with the district attorney's office, then you can withdraw, which means you can take back your plea of either guilty or no contest. In essence, you don't have to go forward if the court does not accept the plea bargain agreement. Now, if the court does accept the plea bargain agreement and you decide later on, within 30 days, that is, that you would like to file an appeal, what an appeal is, you would like a higher court to look at your case to see whether or not you've been wrongfully convicted or whether or not the court committed an error by convicting you. And if you decide within 30 days that you would like to appeal after the court has followed the plea bargain agreement, then you have to get permission to appeal from the court that followed the plea bargain agreement. Now, if the court gives you permission, your case will be appealed up to the Ninth Court of Appeals, which is right above us on the 3rd floor. And they will look at your case. They could either decide to grant or deny your appeal. If they grant your appeal, then they can find you simply not guilty, or they can send the case back down to this court and order this court to give you a whole new trial. Now, if they deny your appeal, then once they deny your appeal, within 30 days of them denying your appeal, you'll have a right to appeal it to a higher court than the Ninth Court of Appeals. You will have to file what is called a pro se petition for discretionary review. Pro se means you representing yourself. You don't have a lawyer is not representing you. And you will be filing this case to the Texas Court of Criminal Appeals, which is located in Austin, Texas. It is the highest criminal court in the state of Texas. And they can either grant or deny your pro se petition. If they grant your pro se petition, they can find you not guilty, or they can order this court to give you a whole new trial. If they deny your pro se petition, then at that point, your conviction will stand. Now, if you're not a U.S. citizen on a plea of guilty or nolo contendere, it may result in deportation, which means you could get kicked out of the country, or it may result in exclusion from admission, which means that if you're outside the country trying to come in, you could be prevented from coming in, or it may result in denial of naturalization, which means that if you file an application to become a citizen, they could deny your application for citizenship. Now, Everyone here for Raymond has been arrested on his or her case. Actually, we have all males today. That's unusual. So everyone have been arrested on their case. And since you've been arrested on your case, you should be informed that every day that you spent in jail, you can get credit toward your punishment. For example, let's say you spent 5 days in jail, and let's say the state has made an offer to you to serve 5 days in jail. Well, you get credit for it. You won't have to serve 5 days in jail because you've already served 5 days in jail. Therefore, you'll be given credit for time served. Now, if they offer you 6 days in jail, that's just simply, and you have 5, that means you only have to serve 1, not 6. Every day that you spent in jail, also, you're credited at $100 per day, which can go toward your fine and court costs. So, for example, if the state offers you a fine and court cost of $500, you spent 5 days in jail, that's $500. That simply means you won't have to pay anything. Why? Because the 5 days in jail has already satisfied that, and therefore you can get what is called your fine and court costs taxed and retired. Now, the state of Texas, when I say the state of Texas, I'm referring to the district attorney's office. Jefferson County District Attorney's Office has a program that is called pretrial diversion. Pretrial diversion is a program which means that your case can get dismissed and you could get it expunged from your record. What an expunction is? An expunction means it can be wiped off, deleted, or erased from your criminal history. And the way that operates is as follows. You have to apply for pretrial diversion. And normally, well, you have to have an attorney who represents you to apply for pretrial diversion. You cannot have an offense that involves unlawfully carrying a weapon or resisting arrest. And it has to be your first offense. So you can't have a criminal history. And if you get into the program, as I said earlier, the case will be dismissed. You complete the program, you could get it expunged from your record. Now, if you are a veteran of any one of the branches of the United States military, the district attorney's office has a program that is called Veterans Court, and it operates just like the pretrial diversion. It's part of the pretrial diversion program, but it's only for veterans. You get into that program, complete the program, case is dismissed, you can get it expunged from your record. Only qualification is you have to be a veteran of any one of the branches of the United States military. All right. Now, this court has a program that is called the Community Safety Initiative. It's normally referred to as the CSI program. And the CSI program is a program that is designed to make Jefferson County a safer place by addressing the issue of what we call recidivism. Recidivism means people committing crimes over and over. And the way we address the problem is we have a myriad of partnerships with local agencies in the community. And the program actually is designed to make Jefferson County a safer place for all of us to live, work, go to school, raise our children, go to church. And the way the program works is if anyone have a mental health issue, you have some type of mental health issue, we have a partnership with Spindletop MH&R. In fact, we have some representative from Spindletop in court today. They can do private interviews. They can do Spindletop can do an assessment, and they can develop a treatment plan for you, either outpatient or inpatient. Also, we have a program with Spindletop as well as Ozar. Ozar is our local drug and alcohol council. And the program that we have with them is for individuals who have problems with drugs or alcohol addiction. And they can do a screening, they could develop a treatment plan, and It could either be outpatient or inpatient services as well as an interview. The other thing is, if you are unemployed or you're looking for a better job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called, it's referred to as CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training program and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you get trained in one of those areas, they will assist you with getting a job. And individuals are getting jobs once they get trained. Also, if you have not finished high school and you need your high school diploma, well, Spindletop has a GED program. I think CICE has a program as well for GED, where you can get your high school diploma. Now, all of those programs that I just mentioned are free. It does not cost you anything. Only thing you have to do is have a desire to be in one of the programs. The other benefit about those programs is that all of those programs can be used as community service. Now, for example, let's say you are required to pay a fine and court costs, and let's say you don't have the money to pay the fine and court costs, then we could put you on what is called a payment plan to pay it off over a period of time. But let's say even if they put you on a payment plan, you won't be able to pay it off. So if that's the case, then we can convert your fine and court costs to community service, and that's pursuant to 42, the Code of Criminal Procedure, section Article 42.15. And so what happens is we can convert we can convert your fine and court costs to community service. And let's say you have an issue, you need to address a mental health issue, and you're in that program. Or let's say you want a job and you get into the program, the CICE program. Or let's say you have a problem with drugs and alcohol, and you get into the program that a Spindletop have or that Ozar has. Or let's say you're trying to get your GED. I mention all of that because all of those can be used as community service. So for example, while you're sitting in class being trained on the job, you're paying your fine, you're doing your community service, and you're being trained. So you're doing three things while you're actually doing one thing. So I always say you're killing three birds with one stone. And so the programs, as I said, are free. It does not cost you anything. Only thing you have to do is have a desire to be in the program. And I tell people this all the time. When you come to county court at law number 2, we don't have court as usual, we have unusual court. And the reason why I say that is not because we're different, but because we are making a difference in the lives of the individuals that come before this bench, and we're making a difference in the community that we serve, which is Jefferson County. The other thing is by you participating in the program, we are producing productive people. And for the most part, productive people do not commit crimes. And so that's the program. And so in Jefferson County and County Court at Law number 2, we do not just arrest the problem, we address the problem. And so we believe if you address the problem, we can make Jefferson County a safer place for all of us to live, work, go to school, raise our children, and go to church. And so that's the program that we have here in County Court at Law number 2. And as I stated earlier, we have some representative here from Spindletop, and we're going to ask that Deputy Hinton, who's our mental health officer, to come forward, and he can tell you a little bit about the program that they have at Spindletop.
Thank you, Your Honor.
Thank you. You're welcome.
Again, my name is Steve Hinton, mental health deputy with Jefferson County Sheriff's Office in Whitesville, Texas. I'm here with two people, Ms. Misty and Mrs. Shelby. They're both qualified mental health professionals from Spindletop. The reason we're here this morning is because the judge has graciously allowed us in this courtroom because he cares about each and every one of you. What we found is that people who frequent the legal system in our court have sometimes underlying issues such as mental health issues or substance use disorders. And that's what we're here for, is to help you. Also, we've identified two obstacles associated with presenting this in a courtroom like this. The first obstacle is we don't know if we don't ask you, so that's why we're asking you this morning. The second obstacle is we don't know if you don't tell us. So as the court proceeding continues, what we're gonna do is I'm gonna go around and I'm gonna speak to each and every one of you. If you wanna speak to us, you can. There's a private room in the back where these two ladies will be glad to meet with y'all and discuss any options that may be available to y'all. And it's not just for y'all, it may be family members that y'all may want information on regarding mental health or substance use disorder. We have a tremendous amount of information that would be available to you and help you actually walk through the system. Does anybody have any questions? Thank you for your time. Thank you, Your Honor.
Oh, you're welcome. Now, ladies and gentlemen, we have earlier passed out some paperwork for you. We'd ask that you take some time to fill out that paperwork. That first document, you'll make your choice as to whether or not you want to hire an attorney, or if you already hired an attorney, you can mark that one, or whether or not you would like to apply for a court-appointed attorney, or if you've already been appointed to a court-appointed attorney. We would know that. But the other thing is, last one, if you would like to represent yourself, then you'll sign on the fifth line, your initial on the fifth line, and then sign at the bottom. And if you are desiring to represent yourself, you need to sign the second page that says waiver. That's the second page that's there. You'll sign that waiver. You read it and sign it. And just before we do that, I'm going to go over it with you right quick for those of you who may be signing that. It says the title is Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And it reads, I have been advised of the nature of the charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 4th day of May 2021 by County Court at Law Number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed to me free of charge, if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel, and if that's your desire, then you will sign your name where it says defendant, and where it says date, you will put the day's date, May 4th of 2021. Now, for those individuals who are desiring to have an attorney appointed to represent them, then you will have to fill out a financial questionnaire. And we haven't, and for those of you who desire to have a court-appointed attorney, then a financial questionnaire is going to be passed out to you. And on that questionnaire, I think it's highlighted. That's the areas that you need to fill out. Just start at the top and just go all the way down. And I think when you get to the bottom of the document, on the left side of that document, it asks you for your income, and that's how much you make a month, or if your spouse has an income, or if you receiving child support, or if you receive SNAP or any governmental benefits or SSI or any form of income. You fill that side out, and then you will, at the bottom where it says total, you just add it up in total. I think the last thing you have on at the bottom is assets. That asks whether or not you own a home or a car, and then you'll put that on, put that amount there. If you do, if you don't, if you don't have any income or anything on that nature, you're just gonna put 0. Don't leave it blank, and don't put not applicable. Just put it's asking for a numerical amount. So if you don't earn anything, just put 0. Okay. If you do earn something, you're gonna put that amount per month. Now on the right side of that form at the bottom, it asks for some of the expenses that you have. It may start off with whether or not you pay rent, whether if you have a utility bills, light, gas, and water, whether or not you have to pay child expenses, And child expenses is not just child support, but if you paying for other expenses, diapers or clothing and things of that nature. It also, below that, it may ask whether or not, let's see, it say below that, it's gonna ask you for your food expense. And that's how much you think you estimate that you make a month. Transportation costs, how much it costs. And when we're talking transportation costs, we're not just talking about gas and oil, but we're also talking about insurance payments. We're talking about car notes. You can put that there because that's part of your transportation cost. If you have a cell phone, how much you pay a month. If you're on probation, you have probation fees, on parole, whatever those fees are a month. If you have medical expenses, you put that a month. And if you have credit card expenses, you'll put that a month. And then you'll total it. Okay. Now I'll just kind of go back up to the top of this document, kind of like 1/3 down where it says I received. And then actually, if you get Medicaid, check that box. If you get SSI, check that box. If you get SNAP, you check that box. If you get TANF, you check that box. And if you get, if you have public housing, you check that box. Okay. So what we're going to do at this time, we're going to be in recess to give the court staff an opportunity to get the information, pick up that information from you. It's going to take some time for us to go through it, and we're going to put you in the categories. You're either going to be in the category where you hire an attorney, category where you apply for a court-appointed attorney, or the category where you would like to represent yourself. So just be a little patient with us. We're going to try to be as efficient as we can. So at this time,